am very pleased to welcome you again to our final panel of the afternoon. First, we will hear from Professor Michael Kent Curtis. He is a member of the class of 1964 here at the University of the South. He has an MA in Political Science from the University of Chicago and earned his JD from the University of North Carolina. Now, as Judge Donald L. Smith Professor in Constitutional and Public Law at Wake Forest University, he is one of the foremost constitutional historians in the United States. His book, No State Shall Abridge, the 14th Amendment and the Bill of Rights, has been called one of the most important and most impressive works of constitutional scholarship of the late 20th century. This assessment made by none other than Professor Akhil Amar, himself the biographer of the Constitution. Professor Curtis's book, Free Speech, the People's Darling Privilege, won the Playboy Foundation Hefner First Amendment Award for the best book of the year. The North Carolina Literary and Historical Society also chose the book as the best nonfiction book of the year by a North Carolina author. Professor Curtis has received the Frank Porter Graham Award from the North Carolina Civil Liberties Union for achievement in defending and advancing civil liberties in the state. Next, we will hear from Gerard Magliocca. He is the Samuel R. Rosen Professor at the McKinney School of Law at Indiana University. He received his undergraduate degree from Stanford and his law degree from Yale. He joined the faculty at Indiana after clerking for Judge Guido Calabrese on the Second Circuit Court of Appeals and working 2 years in a corporate firm. Professor Magliocca is the author of 3 books and over 20 articles on constitutional law and intellectual property. 2 of his books have been featured on C-SPAN's Book TV, including his latest, which we'll hear a selection today, I think, American Founding Son, John Bingham and the Invention of the 14th Amendment. He is an active blogger. His blogs appear at Concurring Opinions and at Balkanization, and he has a forthcoming book from Oxford University Press entitled The Heart of the Constitution, How the Bill of Rights Became the Bill of Rights. He has been awarded for his teaching and in 2013 was elected to the American Law Institute. So please, let's welcome our panelists.
Thank you very much, and thanks Vice Chancellor McCardle and Tanner for your work on this symposium. And I want to thank everybody in the Sewanee community for your participation in this event. I'm a little puzzled because I'm used to a situation where I can always see the screen, but it's behind me here. So if things look a little strange to you, you may know why. I guess I was first interested in, is this positioned right for you? Up, okay. Interested in the Bill of Rights very early in my life. My geometry teacher in high school got me interested in civil liberties. And when I came to Sewanee, it was in 1960. At that time, the Supreme Court was in the process of debating whether it should apply more guarantees of the Bill of Rights to the states. And it was my view that it should, and Justice Black was right. And Professor Gilchrist's political science class furthered my interest in that subject. The one way to think about the 14th Amendment is that it transformed the pre-constitutional era, or attempted to. That was the era of the semi-sovereign state. And basically, as we've heard, the states controlled all sorts of things about their citizens' liberties and rights. And to the extent that the Bill of Rights had anything to do with the story, according to Barron versus Baltimore, it just limited the federal government. So you may have thought, and a lot of people thought, in this period in the 19th century, that as American citizens they had their rights in the Bill of Rights, but that's not true at all. All you had was a limitation on the federal government. You didn't have a right. And the story of the 14th Amendment and the court is the story of the court returning to the semi-sovereign state in significant ways and moving away from the vision of the framers of the 14th Amendment. Albion Tourze was a North Carolinian, an author, judge, member of the State Constitutional Convention. wrote novels on Reconstruction. We had a symposium on him in North Carolina. He was also Plessy's lawyer in Plessy versus Ferguson. And after the decision in Plessy versus Ferguson, he was invited to address a group in Massachusetts, I think some anti-slavery group in Massachusetts, or a lot of prior anti-slavery people. And he said the Supreme Court had been a consistent enemy of liberty and equal right. So when I wrote an article for the symposium on Torzay, I looked at that question. Was it accurate that during his lifetime, say from 1830 to the late 1890s when he spoke, the Supreme Court was a consistent enemy of liberty and equal right? And I determined that that was not right. The Supreme Court was just usually an enemy of liberty and equal right. And that's what you see during this period. Slavery, of course, was a major problem for the United States from the beginning. But by the 1830s, the problem had begun to heat up. There was a sort of a national consensus as to what we should do about it. What we should do about it was nothing. It was such a complex question that people should sit on their hands and button their lips and just not deal with it much. The abolitionists were very inconvenient for this approach because the abolitionist bull charged into this China shop, as many saw it, demanding that slavery be put on the national agenda. Now, initially, the abolitionist idea was that they would explain to slaveholders that they were hopeless sinners and engaged in sin and, recipients of man-stealing and that sort of thing. And the expectation was they would repent. And they would then repent, and that would take care of the slavery problem. It did not work that way. And there was a tremendous controversy about whether abolitionist speech should be permitted or whether it needed to be suppressed. And the controversy was not merely from the South. There's a lot of opposition in the North. So there's a poster from the 1830s. It explains that an abolitionist is going to come and make a seditious speech in favor of abolition, and he must be put down by peaceful means. In other words, he would not be permitted to speak. And really throughout the North, there were these incidents where abolition meetings were interrupted and shut down by mobs. Newspapers that were favorable to the anti-slavery position had their types thrown in the streets and so on. The one effect of this is that slavery and the expansion of slavery particularly became increasingly a key national political issue. But in at least half the country, you couldn't talk about it in the South. And in the North, you had great difficulties talking about it. In 1837, Elijah Lovejoy had been a citizen of Missouri. Missouri was considering a new constitution. Lovejoy, who was a Presbyterian minister and a newspaper editor, thought that Missouri should follow what many of the northern states had done and abolish slavery in its constitutional convention. And so he published arguments in favor of that in his newspaper in Missouri. The result was that mobs broke into his newspaper office and threw the press in the river. And friends raised money, and Lovejoy got another press. And mobs came back and threw that in the river. And I think it went on a third time. And then Lovejoy decided he'd move across the river into the free state of Illinois. So he went to Alton, Illinois, and he was disembarking his press when a mob met him and threw his press in the river. And so Lovejoy and his friends, first they appealed to the local government. They said, look, you need to protect us. We have these people who are doing these things. This violates our rights and our rights of property and speech and all sorts of things. You need to protect us. And the mayor wanted to, but the majority of the city council said, there's no problem for you. All you have to do is shut up, and then you won't have any more of this difficulty. So they moved the press into a stone warehouse. This is a representation of that. And the mob comes back, and one of the members of the mob is planning to set the roof of the warehouse on fire. And so Lovejoy reaches out the window to shoot the arsonist and is shot and killed. And there's a tremendous reaction in the country. And what has gone on as a result of these suppressions of expression is a reframing of the slavery debate. The slavery debate is no longer just about slavery. It's about how slavery is corrupting the American constitutional system. Slavery is making free speech impossible in the American constitutional system. And so, increasingly, from the abolitionists being a small group of people, they're joined by an increasing number of people who support them on the free speech issue. And so the issue is substantially reframed in that way. The effect of the Lovejoy killing is described as a sort of a political earthquake. John Quincy Adams condemns it. All sorts of people condemn it. Not much later, in Philadelphia, the abolitionists have difficulty finding places to speak. So they ought probably to be allowed to speak in public places like courthouses when they're available and that sort of thing. But they're having difficulty, so they build a hall for free speech. And Theodore Dwight Weld, who's a famous abolitionist, and Angelina Grimke, another famous abolitionist woman, getting married. They have their marriage reception in Philadelphia Hall. Both black and white people are invited to the wedding. And because of concern about the pernicious effect of anti-slavery speech and other unregulated speech, a mob comes and burns down Pennsylvania Hall in Pennsylvania. And the governor of Pennsylvania, in a very eloquent statement, condemns this as an attack on free speech. And in the Lovejoy case and later cases, you begin to get some new rhetoric. And the new rhetoric is these acts are an attack on the rights of American citizens, are often described as the privileges and rights or immunities of American citizens. These are rights given to us by our Constitution. Now, from the point of view of a modern law student, you'd say this is not right. This is not right because these mobs are not state actors, right? And by one view of conventional legal wisdom and the majority view, if private people are doing it, it's not an invasion of your constitutional rights. It might be an assault or it might be something else, but it's not an invasion of your constitutional rights. From another perspective, of course it is, right? The whole idea of having a guarantee of free speech is so that you can have free discussion. And when mobs and groups silence speakers, that is a basic interference with the right of free speech. There are a whole host of issues that come up thanks to the abolitionists. The abolitionists have their postal campaign. They've got these booklets. They've got not only written material, but they've got these woodblock illustrations of slaves being mistreated and that sort of thing. And they are sending them through the mail to slave owners. This is part of the idea that you'll show them how bad they are and get them to repent. A mob invades the Charleston post office and they burn the publications. And the United States, the President of the United States says we ought to have a law banning the transmission of these things through the mail. And John C. Calhoun says, no, this is too dangerous. This is federal authority. What we really ought to do is have a law saying the states can ban all this stuff. But there's remarkable opposition to this. And really, some of the interesting things I found, and I did all of this work sort of as a spin-off of my No State Shall Abridge book. What I did was I found these episodes that were referred to in passing in the debates over slavery and before that and over the 14th Amendment. and I looked at these episodes in more detail. And these episodes are really interesting, and a lot of the rhetoric and analysis is very impressive. So you've heard about William Jay, who was the son of Chief Justice Jay. He writes a pamphlet about this issue. The number of congressmen they have a committee, they give a report on the question of whether you can do this. So there's all sorts of discussion of the power of the federal government to limit speech through the mails. And in the end, nothing passes. Congress is deadlocked between the Calhoun faction and the Andrew Jackson faction and the people who think that it's unconstitutional, and nothing happens with it. But in fact, the postmaster just decides he will keep anti-slavery publications out of the mails. And so that's what happens. So what should we draw from this? Let's look a little bit more about what's going on. So, a little closer to the outbreak of the Civil War, you have an incident in the Congress of the United States. Senator Sumner of Massachusetts gives a speech, maybe not in the best taste as some see it, and he suggests that the senator from South Carolina has taken slavery as his mistress. And this is particularly inflammatory because first there's all this problem of slave owners having sex with female slaves, and then, it's considered very bad taste by Congressman Brooks. So who's a relative of the senator from South Carolina. So Brooks comes on the floor of the Senate after it's out of session, and Sumner's sitting at his desk, and Brooks has a cane, and he beats him repeatedly over the head to punish him for his speech on the senator from South Carolina. And there are two views of this event. One you get from the Richmond Enquirer in 1856, and this represents a view from much of the South. They say, this was an excellent thing. Good in conception, better in execution. These uppity abolitionists need to be lashed into silence. And John Bingham, on the other hand, gives a speech about it. He says basically, look, this is an attack on a basic liberty of Americans, and it's the liberty of their representatives to be protected in speech and debate in their assemblies. And this is an attack on this basic liberty. So those two views. I'm going to skip. Oh, I have the problem that I'm not seeing these things, but you're seeing them now. Okay. We've seen the Dred Scott decision, basically that blacks can't be citizens of the United States if they're descended from slaves, and that they are entitled to no constitutional rights whatever, and that the Congress can't keep slavery out of their territories. And the view of the Republican Party and anti-slavery constitutional theory, taken in part from political abolitionists, is that Dred Scott has it backwards. The Due Process Clause of the United States Constitution says you cannot deprive people of life, liberty, or property without due process of law. And although it doesn't apply to the states, as the predominant view is, everybody agrees it applies to the federal territories. So the federal territories are covered by the Fifth Amendment. Therefore, slavery in the territories is unconstitutional. That's in the platform of the Liberty Party in the 1840s, I think it is. It's the platform of the Free Soil Party. It's the platform of the Republican Party of 1856 and 1860. So it's just the opposite of the view of the United States Supreme Court. And in terms of where political discourse is in the country, in the Lincoln-Douglas debates, 1858 or so, I think. Lincoln and Douglas don't agree on much, but they agree on one thing. They agree that Republicans cannot campaign in the South. You cannot campaign for Republican candidates in the South. And Douglas says this proves that the Republicans are a sectional party, and you should reject them because they're a sectional party because they can't campaign in the South. And Lincoln says, well, let Mr. Douglas try to go to Russia and proclaim democracy. This doesn't prove anything except that we have a system of despotism keeping out political discussion. On the before the 1860 election, Hinton Rowan Helper, who's a North Carolinian, publishes a book called The Impending Crisis in the South and How to Meet It. The impending crisis in the South takes the position that the slavery institution has been terrible for ordinary white people in the South, and it's an evil institution, and it suppresses dissent and that sort of thing. And he has a plan that North Carolina should get rid of it by constitutional amendment, the way the other states did. And in the meantime, everybody who's against the slavocracy, as he sees it, should not vote anymore for slave owners for public office, shouldn't deal with them, should stop renting slaves, that sort of thing. And the slaves should have an opportunity, should be freed, have an opportunity if they want to move out of North Carolina and have some money to help them do that, or if they stay, is his view at that point. But Helper has some fairly purple passages in his book. He does say, if the lords of the lash and their cringing lickspittles do not permit us to have free speech on this subject and settle it, with the ballot box as opposed to on the battlefield, then we ought to fight back. And there are more of us than there are of them because slave owners are a minority. And furthermore, 9/10 of the slaves would be delighted to cut their masters' throats. This is something extremely upsetting to the Southerners who are worried about slave revolts. There have been slave revolts. On the other hand, the Republican Party is enthusiastic about Helper's book. So they publish an abridgment of it. They collect money to publish an abridgment of it. Because this is an argument that the slavery system is not only bad for the slaves, obviously, but it's bad for the ordinary white working people. And so they have the abridgment of the book. And the book is endorsed by over half, or about half, of the Republicans in the, I keep moving away from this microphone, in the House of Representatives. It's endorsed by the person who's the Speaker of the House in 1866, when he has endorsed it before. He's the Speaker at the time of the 14th Amendment. It was endorsed by the chair of the Judiciary Committee at the time of the 14th Amendment. It was endorsed by John Bingham. It was endorsed by 3 of the Republicans on the Committee for Reconstruction. And in the meantime, the view in the South is this is a criminal book. Because the South has these laws that say you can't say or print things which would have a tendency to cause slaves to become discontent or rebel. And anything which would make them upset with their condition could have that effect. This book could have that effect. Therefore, it's a felony to distribute the books. So an enterprising grand jury in North Carolina wants to extradite people who are who have endorsed the project. Among other people, they asked the governor of New York to extradite some people in New York who were involved, including the governor himself. And it does not work, of course, because at that point, the states are making that decision and the northern states aren't doing it. There's Helper's book. There are the people who supported it. Congressman Lovejoy, he's the brother of the slain minister. And he says, look, I claim the right of distributing this book anywhere. in the entire country on the question of slavery, to which the privileges or immunities of the Constitution extend. And Congressman Martin of Virginia says, "Come on down, we will hang you." And Lovejoy says, I don't doubt it. But note the phrase he uses. So Lovejoy, like Bingham and others, has the view that the right to free speech and free press is a privilege and immunity of citizens under the Constitution. This is ahead of the time in terms of what will happen with the 14th Amendment. It's not constitutional law at the moment, but it's part of a common faith of many of the members of the Republican Party. So this is part of where the idea that American citizens have these rights, including rights of free speech and press and all the other rights in the Bill of Rights, come from. And so Bingham, for instance, in 1866, argues that we need an amendment to enforce the Bill of Rights. And he cites Barron versus Baltimore. And in addition to citing Barron, he reads from the decision to show people, because a number of Republicans have thought they can pass things like the Civil Rights Act, making black citizens, and they can do it. Where's the power come from? It can come from the Fifth Amendment. But Bingham says, no, look, to be certain that we can do this, we have to change the law. We have to have a constitutional amendment. And we do get one. So in North Carolina, Professor Hedrick is a teacher at UNC. He teaches chemistry, a very gifted chemistry teacher. And he tells some of his students that he's planning to vote for Fremont in the 1856 election. And word of this gets out. It's published in the Raleigh newspaper. And the Raleigh newspaper insists something has to be done about it. The Board of Trustees fire him. So he decides to go home to Salisbury, North Carolina, and then a mob drives him out of the state. And the newspaper celebrates. It says, we may have elevated him a little bit, but we've established this important principle that nobody who supports John C. Fremont for president should be able to breathe the air or trod the soil of North Carolina. So you see the extent to which any sort of meaningful democracy on the slavery issue is undermined. And this is not just about abolitionist speech. This is about Republicans. And the other thing that the Raleigh newspaper says a little later is you've got to look for any of these Republican newspapers, any letters franked by Republican congressmen, and the postmasters have a duty to burn them before they get to the recipient. Daniel Worth was a minister and a political activist, and he's circulating copies of Helper's book. And he gets arrested. And he gets arrested after having been outed by the Raleigh newspaper. And the newspaper celebrates again and says, we'd remind postmasters you're supposed to burn all the copies of this book, all these things that are Republican literature. The North Carolina Supreme Court upholds the conviction. And they say, look, of course, if one person gives this book to another person, and they do it for the purpose of showing how awful these abolitionists are, then that's all right. But if you're doing it for the purpose of trying to convince people that of these abolitionist ideas or these anti-slavery ideas, then it's criminal. The North Carolina legislature amends the statute which makes it a crime to say things which would have tendencies to cause slaves to be discontent, so on, and provide the death penalty for the first offense. Well, I think I've talked long enough. I'll give the basic picture here is that one argument about the 14th Amendment is that the 14th Amendment was just about the newly freed slaves. That's the argument in the slaughterhouse cases. And that was the whole issue. But of course it isn't. It was an important part of the issue. It's something the Republicans were dealing with in, for instance, the Civil Rights Act of 1866. And when they passed that, they said black people would have full and equal benefit of all provisions of protections of person or property enjoyed by white people, which incidentally is a phrase that had often been used to include the Bill of Rights. And these black codes had all sorts of provisions which not only discriminated against blacks, but discriminated against blacks in terms of prohibiting their rights of free speech, free exercise of religion, protection against cruel and unusual punishment, and so on. So a major purpose of the 14th Amendment was to attempt to restore guarantees of the Bill of Rights and to restore a system where we would have democracy. And of course, in Reconstruction, there was this effort to have a multiracial democracy, and it was met with opposition. The Congress attempted to, when they were faced with Klan and similar activities, they passed a statute attempting to punish people who did that. 10-year felony if you did things that you gathered together in an attempt to intimidate or harass or injure people because they'd exercised any right, privilege, or immunity of citizens of the United States. But in the slaughterhouse cases, the Supreme Court said there were two kinds of privileges or immunities. One were those of citizens of the United States. Those were the right to protection on the high seas and to when in foreign lands and to visit the sub-treasuries and to go back and forth to Washington, D.C. And then there were the privileges and immunities of state citizenship. And the privileges and immunities of state citizenship were everything else, all your basic civil rights. So slaughterhouse was an indication that these laws would be held unconstitutional. And in 1876, the Supreme Court did strike down one of these civil rights statutes that was used to attempt to protect a group of black people in Louisiana in their exercise of the right of assembly and so on. And the court said, basically, look, the Bill of Rights doesn't apply to the states. Furthermore, these people are not state actors, they're private persons, so they have the state action syllogism. Klansmen and other private terrorists are not the state. The 14th Amendment only limits the state, no state shall. Therefore, these people are not reached by the 14th Amendment. And that is, that's probably as far as I should go with this story. But this part of the story shows that there's more to the 14th Amendment than what the slaughterhouse case said. First, they said it's all about blacks. That's what it's about. You know, that was the purpose of these amendments. So they airbrush all of this story of repression of free speech and bad searches and seizures and that sort of thing from the story. And then second, incredibly, in this amendment, which supposedly is all about protecting blacks, where are we going to protect them? On the high seas and in foreign countries. Yeah, what sort of sense does this make? Not much. We, maybe in the discussion, we'll talk a little bit more about some contemporary issues, but I think I have talked long enough, and I'll stop there for now.
Okay, great. Okay, last talk of the day. So will we end with a bang or a whimper? We shall see. I want to start by thanking all of the organizers of the conference. It's been tremendous so far, and it's also a special honor for me to be on a panel with Michael, who is a real pioneer in the field, and this is my first opportunity to present with him. Now, I'm going to talk about how the debate over Tennessee's readmission to the Union in Congress 150 years ago exposed some very basic differences over Reconstruction that shaped the future of the entire South and indeed the entire nation. And part of my story is going to be told through the personal rivalry between Thaddeus Stevens and John Bingham, who were the two House Republican leaders who wielded the most influence over Reconstruction policy. While they ultimately agreed that Tennessee should be readmitted when it was, they disagreed about the conditions under which Tennessee should be readmitted, which was the first of many debates that they had, very testy debates, about what the price of readmission should be for the ex-Confederate states. Okay, so why was Tennessee so important in 1866? Now, those of you who are born and bred here would probably say, oh, of course we were important. But for those of us who are not from Tennessee, right, this is a question that we need to ask. And the answer, of course, is that Andrew Johnson was President of the United States, and he was from Tennessee. Now, why was Andrew Johnson president? Well, he was the only Southern senator who remained loyal to the Union in 1861. All the rest of them left, including Jefferson Davis. But Johnson stayed loyal and, well, you could say defected from the Confederacy, if that's one way of putting it, and became a sort of symbol of a kind of good Southerner, or at least a pro-Union Southerner. Now, in 1864, Lincoln named him vice president in part because he thought it would help him attract some votes in the border states as well as among conservative Democrats. Now, it must be said that the selection of Andrew Johnson as vice president was almost certainly Lincoln's worst decision. Now, it's easy to see why he made that decision. First of all, presidents and presidential candidates are notorious for not paying enough attention to who their vice presidential running mates will be, right? They're not really thinking about them as president. They're thinking about them as how are they going to help me get nominated, how are they going to help me get elected, or how are they going to help me govern. Secondly, in 1864, Lincoln's prospects for re-election were not looking so good in the summer. The war had dragged on for a long time. There was a bit of a stalemate, especially with the progress of Sherman's army, and then also Grant's sort of stalemate with Lee in Northern Virginia. And so Lincoln probably thought that he needed as much help as he could get, and that Andrew Johnson was someone who could help him a lot more than the vice president he had, who was Hannibal Hamlin, which is a rather dramatic name, from Maine, who was a much more ardent anti-slavery person and would have been a much more kind of anti-slavery president had he been kept on the ticket for the second term. So anyway, after Lincoln's assassination, President Johnson and Congress soon enter into a very prolonged discussion about how to handle the ex-Confederate states that have been defeated. There is an overwhelming Republican majority in Congress. Johnson, of course, is a Democrat. Now, they have very large substantive differences about what to do, but before you even get to that, there's a basic question of who gets to decide what to do with the ex-Confederate states. Now, President Johnson's view was he should get to decide because he's the commander-in-chief, and the South is under military occupation, being run by sort of these temporary civilian administrations that have been set up. And so he was in a position to dictate the conditions under which they could be readmitted. Congress took the view that no, readmission of a state was a political act, not a military act. It took an act of Congress to make a state, and so it should take an act of Congress to make a rebel state, or whatever, however one wanted to describe the status of the ex-Confederate states, a fully fledged state again. Now, when the new Congress convened in December 1865, and representatives from the ex-Confederate states showed up, having been elected, and said, okay, we're ready to resume our seats, including Alexander Stephens, the vice president of the Confederacy, who was coming from Georgia. The Republican Congress took the bull by the horns and simply refused to seat or acknowledge these people. There were various arguments put forward as to why Congress had the authority to do that. I mean, we can get into that later if you want. But basically their position was, no, you can't be part of Congress until we've decided to readmit your states in good standing. Now, when would that be? Well, there we had a big difference not only between the president and Congress, but between members of Congress themselves. So the president's position basically was that what got an ex-Confederate state back into the Union was, first, they had to ratify the 13th Amendment, abolishing slavery. Second, they had to swear a loyalty oath to the United States, basically, don't do it again, right? And third, that they had to repudiate the Confederate debt that had been racked up during the war. Congressional Republicans were in agreement that this was inadequate, that more should be required, in part because of the fact that none of those conditions really did anything to protect the rights of the freed slaves. So, what should be required, though? To answer that question, Congress formed the Joint Committee on Reconstruction, about which you've heard quite a bit, and you can think of this as sort of the Constitutional Convention of Reconstruction, right? That is, they are the proposers or the drafters of the language, and they do that behind closed doors, just as the Constitutional Convention drafted the Constitution behind closed doors. And then after that, their proposal has to be ratified, though by a different process than the process by which the original Constitution was ratified. Now, two of the leading members of the Joint Committee are Thaddeus Stevens and John Bingham. Now, Stevens, I love this picture. It's just a great, looks like almost like a marble bust. Stevens is probably a more familiar figure to you. First, for decades, he was the kind of boogeyman for Southern history as sort of the leader of radical Republicans. More recently, if you saw the movie Lincoln with Daniel Day-Lewis, right, Tommy Lee Jones got to do the performance of Stevens. Stevens was from Pennsylvania. He was a longtime anti-slavery activist, both as a lawyer and then as a local state politician. He reached Congress in 1858 and quickly kind of earned a reputation as being exceptionally adept in debate and in parliamentary tactics, and notably biting, I think, in his comments. I'll sort of give you a couple of examples in a minute. Now, Bingham, though he's been mentioned a lot in this conference, is one of the few places where his name gets invoked a lot, right, is someone that you probably would be less familiar with. He was from Ohio. He was born in Pennsylvania, but spent most of his life in Ohio. Again, he was basically a lawyer, local political official, and then anti-slavery activist. He reached Congress in 1854. And it's fair to say that Bingham and Stevens had almost identical views on slavery until 1866. That is, if you look at their voting records and at their views that they expressed in Congress in the early years, they were grouped almost always as part of the radicals or the most sort of anti-slavery members. Now, this is interesting because later they become big rivals, so this is why I mentioned this. And they worked on many issues during Reconstruction together, not only on the Joint Committee to draft the 14th Amendment, but also they were part of the team that ultimately tried Andrew Johnson's impeachment in the Senate. Here's an illustration of the two of them presenting the charges of the House to the Senate as the initial part of the impeachment trial proceeding. Stevens is with the cane, Bingham standing without a cane. And here later is a picture of all of the impeachment managers, Stevens with the cane. Stevens was in ill health by this point and died not long after the impeachment trial ended. And Bingham is all the way on the right, seated with the sort of big sideburns. On the left, seated, is Benjamin Butler. Some of you who are Civil War buffs may know a great deal about him. Now, as I said, until 1866, Stevens and Bingham were pretty much in agreement about what ought to be done with respect to slavery or Reconstruction. But that started to break down. And one of the first very important breaks came over the question of what to do about Tennessee. Now, why is that? Well, the question was, should the ratification of the 14th Amendment be the condition that an ex-Confederate state had to meet to come back into the Union and be part of Congress, or should more be required than that? Bingham's view, I'll sort of go back so you can, okay. Bingham's view was that ratification of the 14th Amendment should be the end-all and be-all condition. Now, he had several explanations for this, and we can sort of think a little more about sort of why he believed this. First of all, Bingham was a strong believer in sort of what might be described as legal language or formalism in constitutional law. So in other words, he cared a lot about what the text of the Constitution said, and therefore it was very important to him that the 14th Amendment be made part of the Constitution. He thought that was just a critical step, indeed the critical step, to achieving the kind of racial equality and racial justice that he thought was necessary. Second is, as you've heard many times, Bingham wrote most of Section 1 of the 14th Amendment. That is, the portion that guarantees equal protection and due process of law in particular. Now, I don't know about you, but I think if I had written an important constitutional provision, I might take a certain pride of authorship in that and enhance its importance in my own mind, perhaps above where it really should have been. So, I mean, there was a sort of vested interest once he had drafted it and had come to the floor of Congress to say, yeah, you know, and it's very important that this be the condition for ratification. The other thing about it is to say that Bingham took the view that to require more would be impossible. It would be impossible to achieve. It would be impossible to achieve both in terms of what you could get the South to agree to, but also what you could get Northern public opinion to sustain. Now that's a trickier argument because, of course, that requires us to go back in time and try to put ourselves in the mindset of 1866. One thing that may have influenced Bingham's views about this when he approached the question of Tennessee's ratification or readmission is that initially, when Bingham was in Congress, his district in Ohio was what we would now call a safe district. That is, he won by very large margins, and he could kind of say whatever he wanted with respect to slavery or issues of equal rights. Well, after the 1860 census, his district was redrawn, and in 1862, he lost his race for re-election. And 2 years later, he ran again, and he won by a very close margin. And thereafter, all of his races were very close. One time he won by 500 votes, another time he won by something like 1,000 or 2,000 votes, until he once again was turned out in 1872. He didn't even get renominated. So it's fair to say that someone from a district like that might have been much more sensitive to the thought of what would public opinion tolerate, or what is going to be helpful or harmful to the Republican majority in the House than someone from a safe district. Now, basically, Stevens took the view that more than the ratification of the 14th Amendment was required. Like what? Well, voting rights for African American men, property for the freed slaves, and the breaking up of the sort of plantation estates, or what you might call the slave-owning elite, and the wealth that had been built up by the slave system. Now, you could say, in some sense, Stevens either was more of an idealist in this respect or more of a realist, depending on how you want to look at it, right? In other words, either he was asking for things that couldn't happen, or he recognized that just changing the law wouldn't be enough, and that you had to do more if you were going to get to a real form of equality. Okay, now, despite these disagreements, right, what they agreed on was it would be nice to readmit Tennessee as rapidly as possible. Now, not long after Congress passed the 14th Amendment by the required supermajorities in the House and Senate, Tennessee ratified the amendment. Now, maybe later we can get into the question of why did Tennessee ratify the amendment so willingly when the other southern states didn't. But one thing to point out is they ratified it even though President Johnson was opposed to it, which was a kind of early indication that President Johnson's political clout was pretty limited, as he would prove again and again over the course of the next couple of years. So Tennessee ratified the amendment, and then they came to Congress and said, okay, well, we've ratified the 14th Amendment, so now we want to come back into Congress. Now, why was it appealing for Congress to accept this pledge and readmit Tennessee when it did? Well, first of all, it would show that Congress was getting something done, right? Hey, one of the ex-Confederate states was going to be restored to full statehood. So there's progress being made, right? And then it might set an example for other southern states that would want to come back in perhaps quickly. Secondly, they knew that President Johnson would not veto a law that readmitted his home state. That would be extremely embarrassing for him to do. Thus, if Tennessee were readmitted through an act of Congress, that would establish the principle that, in fact, it was up to Congress to decide when states were readmitted, and that point would more or less be conceded by the president. So many members of Congress, Bingham especially, were keen to readmit Tennessee once they had ratified the amendment. But there were members, including Stevens, who said no. First, we want Tennessee to guarantee voting rights to African American men. That is, it shouldn't be enough that they're just ratifying the 14th Amendment. Let's impose one other condition, which is basically rewrite your state constitution to say that African American men have the right to vote. All right, so Bingham said that this was a bad idea, and he gave two reasons. Okay, and I'll give you a quote for the first one. He said, "Justice for all is not to be secured in a day." I guess that's what you said then instead of Rome wasn't built in a day. No. But anyway. "And he is the wisest statesman and the most faithful to duty who will seize the opportunity this day presented to restore a state to its proper place in the Union and thereby add one additional vote of a free people in aid of the final ratification of that amendment to the Constitution." Now, the last point was, hey, we need to get 3/4 of the states to ratify the 14th Amendment. Here's a state that has ratified the 14th Amendment. Why are you looking a gift horse in the mouth, right? This is one vote. Let's take it because it's going to be hard to get to 3/4, and we can talk later about some of the complications that ensued with that. The other thing he said was, well, look, there are northern states that don't give voting rights to African American men, so how can we insist that Tennessee do so if, let's say, Ohio, Bingham's home state, didn't? That didn't make any sense, he said. Okay, ultimately, Bingham's views prevailed, and the amendment to require Tennessee to provide full voting rights to African American men was defeated, and then the House, and then Congress as a whole, proceeded to vote to readmit Tennessee. Actually, see, an interesting aspect of my study of Bingham was that even though Stevens gets more attention as the leader of the Republicans in the House, more often than not, he would lose these debates to Bingham, I mean, for good or ill, but Bingham tended to prevail in persuading the House to go one way or another. Okay, now, what happens after Tennessee is readmitted? Well, there's the fall election, right? And the Republicans are looking to try to either maintain or increase their majorities, and President Johnson goes out to campaign against Republican candidates to try to knock down the Republican majority in advance of his views of Reconstruction. So what does Bingham say on the stump in one speech? He says, to voters, if you rally in the fall, every state south will rally to the lead of Tennessee and ratify the amendment. Is that not worth striving for? So again, he was holding out Tennessee as this example of progress that was being made, and here's how we continue that progress. Elect Republicans, right? And don't go down the path that President Johnson wants to go down. Now, the Republicans do, in fact, win an overwhelming victory in the 1866 midterm elections. And when they come back to Congress, then Stevens and Bingham sort of renew their debate about what to do with the other 10 remaining ex-Confederate states. And Stevens introduces legislation which ultimately becomes the first Military Reconstruction Act, which says that basically the other states ought to be required to have African American male voting to ratify the 14th Amendment, and then, well, we'll think about what else we might ask them to do before we're going to readmit them, right? He would not concede that ratification and voting rights for African American men was enough. Bingham obviously was against this, and he said, in part, look, Tennessee has set a precedent, and that was the precedent against which the elections were just held. So you can't go back on that now and start asking for more conditions. You have to go with just saying the only condition is ratify the 14th Amendment. Now, at this point, Stevens was quite exasperated with Bingham, and hurled all sorts of insults at him. I mean, I'll give one, as he told one reporter, the trouble with men like Bingham is that they have no bone in their back and no blood in their veins. He compared him to Stonewall Jackson. I mean, it was, pretty nasty. Bingham was not as good at doing invective, I would say, as Stevens was, although it is reported that when they were trying to work on the impeachment trial of Andrew Johnson, that one person felt they just had to leave because they were just tired of hearing all the profanity that was sort of being exchanged between them in these meetings. So that gives you an idea. Okay, so what was the result of this sort of 1867 debate between Stevens and Bingham? A kind of compromise. The Military Reconstruction Acts provided that, yes, ratifying the 14th Amendment would get you back in the Union, but it also said that the process under which you were going to have elections for the convention that was going to decide whether to ratify the 14th Amendment in a given state had to include African American male voting and had to be done under the protection of the Army. Okay, so that was a concession that Bingham ultimately felt like he had to make to get the bill passed, right? And also, you might say in some ways it was a change in view because eventually he became a much stronger proponent of African American voting rights than he was, say, in the period 1865, 1866, at least in terms of what the federal government could do to compel states to guarantee such rights. Okay, now, that's the role of Tennessee in the debate over Reconstruction. So let me wrap up by asking this question. Well, was this all a mistake? Meaning, did the early admission of Tennessee screw up Reconstruction in some sense? Because it was stated with pride in your opening remarks, Tennessee was very early in ratifying the 14th Amendment, but if they hadn't been, then they wouldn't have been admitted early, and maybe better things would have resulted in terms of more conditions being attached to readmission than were attached by the political circumstances as they were in the summer of 1866. It's hard to answer that question because that links up to some other questions that have been raised here about kind of how do we go back and think about what was possible or not at this time. One thing to say about it is that there was a great heavy lift involved in getting Reconstruction as much as what was done. Now, let me give you an example. In 1867, Ohio held elections for the state legislature, and one issue that was put on the ballot to try to gin up Republican turnout was a constitutional amendment to the state constitution that would have said, we're going to have African American male voting, because Ohio didn't have it, right? And Bingham went out and campaigned hard for it, gave lots of wonderful speeches, and it lost, okay? And not only did it lose, the Democrats won control of the state legislature, and when they got into session, the first thing they did was repeal the state's ratification of the 14th Amendment, which Congress proceeded to disregard, but that's a whole other story. So, I mean, that was Bingham's home state. So you could sort of see that, wow, you know, it wasn't like there was this huge reservoir of public opinion, even at that point, let alone later, for sort of expanding or enforcing these rights. Now, the other thing to say about the sort of admission of Tennessee is a comment that General George Marshall made about Franklin Roosevelt after the Second World War. He was asked at one point, well, what did you learn about politics and trying to fight a war during your time serving as FDR's, you know, in effect, Joint Chief type person? It wasn't a Joint Chief of Staff then, but it was kind of the same thing. And he said, well, sometimes the American people have to be entertained. Now, what did he mean by that? He meant sometimes you have to do things politically for symbolic or morale-boosting reasons that have not much to do with substance, but that if you don't do them, you know, you're taking on risks of losing the support that you need to fight the war successfully or to succeed in politics. Now, I say that because you might say, look, the quick admission of Tennessee did have important symbolic value in 1866 and was a kind of morale booster of sorts for people who thought maybe Reconstruction was going to last forever, it was going to be hopeless, and maybe that was helpful in sustaining a great Republican victory in the fall elections of 1866. Now, how you trade off that short-term gain, right, for whatever long-term costs there are is like kind of part of what makes politics difficult, right? So it's hard to know whether we can go back and easily critique that decision, but that probably explains in part why that decision was taken. So, thanks for listening. Okay, yeah, that's a complicated one. So, okay. Well, the first question that they had to figure out was, were you going to say that amendments needed 3/4 of all the states or 3/4 of the northern states? So there were different views about that. Now, ultimately, the answer that was arrived at was we need 3/4 of all the states, because if you just did it with 3/4 of the northern states, it would never be considered legitimate by future generations. Granted, you could say it still wasn't considered legitimate by many anyway, but there was a sort of stronger claim of legitimacy because it got 3/4 of all the states. Now, the second thing is, okay, well, how do you, well, what about the fact that some of the states that they got to get to the 3/4 were doing it under less than under unusual circumstances, let's put it that way, right? Meaning the choice was, well, you can ratify this, or you can stay under military occupation indefinitely. To what extent, you know, does that matter? Well, there were different views put forward about that. I mean, ultimately, you know, one thought was to say, well, you know, you still have a choice, right? Hey, we don't have all completely free choices in life. Lots of people vote for things or vote for a lesser evil or whatever, and so why is this any different? Another problem was, well, what about states that attempted to withdraw their ratifications? Now, Congress took the position that, well, it was up to them to decide whether a state had ratified, and if they wanted to count them as a yes, then they were counted as a yes. And ultimately, it was determined many, many decades later, there was a Supreme Court case in which the court said, well, you know, that's just sort of a non-justiciable political question. It's kind of up to Congress to decide whether 3/4 of the states have ratified an amendment. Bingham, interestingly, took many different views of this question and kind of went back and forth, and finally kind of was reluctantly agreed with we need to get 3/4 of all the states, and so we have to, even if that means we have to take special measures to get some southern states to do it so that we can get to 3/4, because you needed some of the ex-Confederate states to do it in order to get to a 3/4 number.
Yeah. Yeah, it's to understand how tough it is. A lot of people in the North agreed with them. They said things like, Chancellor Kent, I think, look, since they're in the presence of this very combustible material, we just can't have people lighting matches. And the idea was you could have big slave revolts. If you have big slave revolts, not only is that a problem for them, but it's a problem for us because we're required under the Constitution to come in and help them. And not only this, but this activity is going to polarize the nation into sectional. We'll have a free state section and a southern section, and it'll end in a civil war. And yes, I think the thrust of what you have to say is this is a serious conundrum, isn't it?
Dangerous abolitionists was a concept in many northern states.
Yes.
Had a referendum in the north about abolition. They wouldn't
No. The thing that helped them the most was the attack on their free speech rights.
Yeah.
That helped the issue get transformed to one into what sort of country are we going to have? It's a conundrum, but the other side of the conundrum is Francis Lieber said to the Southerners, look, I think this is a letter to John C. Calhoun. If you don't allow people to discuss this issue, that means it can never be solved peacefully, and it can only be solved by war. And in fact, if you just shut down discussion, that's a problem. And it's not consistent. If it was a major issue before the country was whether or not slavery should be limited to where it was or could be expanded into the territories. And the Republicans and the anti-slavery parties were containment, like we wanted to contain the Soviet Union. And the position of the Southerners was, if you do that, then we've got to go to war over it. So you couldn't even discuss in fairly peaceful terms the major issue before the country. In a way, I'm slipping away from your hypothetical because I'm moving into the other things that they insisted on suppressing. But yes, it's tough. It's tough. And it may show that maintaining a slave system just is not going to work well in a democratic society if you really want to keep a democratic society. Yeah.
It also showed that what they wanted to say was worried about slavery, but also your thought very carefully shown. There was already people that using white Southerners against instead essentially using, or it wasn't, they're being suppressed, using in some sense kind of market society to isolate the slaveocracy. And that is an argument that you might say they're trying to defend. They just don't think they're ultimately going to win that argument. That they see the writing on the wall, and that's why they're willing to go to war. They're willing to suppress speech. If that is the perspective, it puts a somewhat different take on them. When we need a revolution to do these things. It actually suggests that in the United States, both because of democracy, free speech, and the market society that it creates, there was already a revolutionary structure that was a huge problem for slavery, and they knew it. And so that was a somewhat different perspective. I think puts it, understand the whole failure of slavery is much more consonant with the founding than having it as sort of two separate foundings.
Interesting. So you don't see a second founding.
Well, that there's it moves out of free speech, democracy, and the market society. That's what has isolated the South and actually forces them to fight a war which they think they're likely to lose.
Yeah.
Anyone who looks at it, they're not in good shape. So that's what isolates them. And of course, this is an important continuation of this structure. But again, I think their recognition that they're likely to lose this argument, which is, I think, a lot is what's behind suppressing not only because it's a slave rebellion, but how you can appeal to workers in their society, suggests that there is this continuity, and we shouldn't separate out it quite as strongly as I think some people would like to do the original founding from the Reconstruction Amendments and the principles there. That's just a perspective that comes, at least to me, from your talk.
Yeah, for a lot of Republicans reading debates and things in the Congressional Globe and before and so on, they saw the question that the original Constitution was founded on this evil. It was protecting this evil, because you had to return fugitive slaves. There was a 3/5 clause. All of these things were problems. You had to put up with it because you had to put up with it, but it was evil. It was inconsistent with the principles of the Declaration of Independence. And as they saw it, we were moving the nation closer to the principles of the Declaration of Independence. And it's important to remember that before the Civil War, the Southerners, congressmen, had gotten to the point of saying the Declaration of Independence was a self-evident lie. So they were openly repudiating it. So there's this big chasm in that way. And of course, they want the northern states to shut up and not criticize them. And they think that's essential to their security. Yeah.
Quick question for Gerard. Biographical question. Did Bingham live long enough to write enough for you to say he self-consciously thought of himself as the second founder? Do you think he's creating a new constitution?
I think that I suppose one thought is for a politician to come out and said, I'm creating a new constitution would have not really worn well, right, public. So I don't know that he would have said that. I think he took the view that that it was, in effect, he was following the inspiration of the right parts of the original Constitution. So, did he think he was launching a kind of revolution? See, for example, as Michael knows, Bingham's thought about the Bill of Rights and its relationship to the states was, well, the states always had a kind of duty to enforce the Bill of Rights. It's just that the Constitution didn't provide the means by which Congress could compel them to do that, or a federal remedy. Now, then his answer was, well, why is that? Well, because of slavery. So that's not quite the same as just saying, well, we're going to impose, create something totally new in putting the Bill of Rights on the states. Now, of course, he might have said that because he wanted to make it sound less radical than it was. But I think everyone, well, almost everyone in that period spoke, I think, in the language of continuity with something. Now, I mean, whether the something was a declaration or something else.
It's interesting with the Republicans how much they assume that their ideas are consonant with the true view of the Constitution. So, for instance, they don't even add the citizenship clause to the 14th Amendment until the very end. And the reason is they've been arguing all along this is the law and this is the right constitutional law, and they're just assuming that. But of course, Dred Scott is there staring them in the face. And Bingham and a number of them have their view that, these privileges and immunities in the Bill of Rights are rights of American citizens that in some sense are binding on the states. Different ones have different views. And yeah, so they don't think of themselves as dramatic innovators. On the other hand, they do say, boy, things were inconsistent with the Declaration and now they will be.
He dies in 1900.
But he's in Japan.
Right. Well, yeah. So he spends he's ambassador to Japan for 12 years after he leaves Congress, and then he comes back and he more or less retires. I mean, by the time he's about 80, he started to have dementia. So at that point, he doesn't really, there's not much going on, I suppose, in his thinking. But unfortunately, his correspondence is such that one doesn't really have a clear idea about what he thought about what happened after he left Congress. I mean, just not much has survived.
We have a question in the back, yes. That's Oh, yes. If on the issue of enforcement, if you understood me to say they didn't think that was a big deal, Bingham thought it was a very big deal. He quotes Barron versus Baltimore. We can't enforce it now. We have to be able to enforce it. We must do this thing. So he recognizes, although a lot of his colleagues don't, that because of Barron, you just have a big question. And Bingham really writes the amendment really, from my view, very well. He refers to privileges and immunities, and if you look at English history, the American Revolution, the battle over the Constitution, the battle over the Sedition Acts, up through the Civil War, constantly people are referring to free speech and press as privileges and immunities. I wrote a law review article, it was about 80 pages with examples of that. And the other thing he does that fits very well is he's following Marshall's directions. Marshall has said in Barron, if you want to make the Bill of Rights, if they wanted to make the Bill of Rights apply to the states, they would have said no state shall. And so Bingham said no state shall, and then in Congress in 1871, he points out that he followed the cookbook for all the good it did him. Yes?
So we've talked a lot, and I'm thrilled about it, to focus a lot on politics, values, morality. And to some degree we've talked about this, but I really want to invite you all to refer somewhat, if there's a narrative that exists, to the perspectives on the economy in the discussion of the 14th Amendment. I wonder, whether anybody at this time anticipated any immediate effects fortunes and the like. But I mean overall in terms of what the average person would feel as a result of, you know, the adoption of the 14th Amendment. Is there a story to be told about the founding or the refounding of the 14th Amendment and its effect on the American economy as these framers understood it? Maybe that's an argument both
Yeah.
before and during the ratification.
Yeah, that's a great question. I don't know. The one economic thing I'm sure of is, and it might have been very difficult to do, the great mistake in Reconstruction was not having agrarian reform, was not giving land to the newly freed slaves. I think Harrington and Daniel Webster and all sorts of people said, look, the sort of political system you get is going to depend on how widely dispersed property is.
Yeah, I think it's fair to say that Bingham either didn't care about or didn't understand economics or anything of the sort, right? There's nothing really in his discussion at all. It isn't even as if he's trying to refute Stevens's arguments or the arguments of others that we needed to do, say, redistribution of property. Just never talks about it at all. You know, it's also fair to say that he leaves Congress right about the time that those issues start to become more important. So maybe if he had been around for longer, he would have been forced to deal with them and forced to think about them, but it was just never something that kind of came on his radar screen.
I think one, no, excuse me, go ahead.
I'm just going to ask, are you talking about economic consequences or conditions in the 14th Amendment? Is that where it would appear?
Well, there was the discussion after the Civil War, should we do something for the newly freed slaves? You know, they've labored all this time. Should they be given 40 acres and a mule or something like that? I think probably if you'd done it just for the slaves, that might have been a problem, but maybe you could have taken the confiscated land and, you know, done something broader.
What would you think of the proposition that it's not there because it would make it infinitely more difficult to get southern states to agree to?
Yes. I think that's a significant point. One conundrum of the 14th Amendment and how we deal with it is the problems of things like segregation. And we look at the civil rights cases of 1883. But the problem, as I understand it, is Republicans in the 39th Congress, you know, they got rid of segregation on streetcars. They did segregate the galleries of the Senate, which was a great improvement because before they kept black people out. They segregated schools in the District of Columbia, which was a great improvement because before you hadn't had any schools for black people. So in cases like the 54 Brown decision and other cases, the defendants argue, look, or the interracial marriage case, they argue, look, this is not what the framers expected. We know what they expected at the time because of what they said. And I think the answer to that has to be that yes, many of them expected that segregation was okay. But they also gave us principles. They gave us principles like we're not going to have a caste system. We're not going to have any irrational discriminations. And so you don't have the simple choice of following the framers or not following the framers. You have the choice of following their principle when you know that their application is lunatic in light of what we know now, or following the application which is lunatic. Because of course segregation promoted a caste system in all sorts of horrible ways. And of course these bans, as we see it today on interracial marriage, were irrational. That was Stevens' test. So I think that's how I think I try to answer that conundrum. But it is a conundrum. You got to admit the history is there. They had failed to keep up with the times as a result of being dead, as Russell Baker put it.